Good morning, ladies and gentlemen. It's been a wonderful day, and I would like to invite my panel first before I give my little talk. Mr. Sai from Yes Bank, please come, and Ms. Prachi, and Mr. Nishant from INDUSLAW, and Mr. Ashutosh from Khaitan and Khaitan. I think just to save on the time, I'm not going to speak much about the speakers, but I can only tell you one thing, that they're all accomplished ones in their own way. Ashutosh representing Khaitan, and Khaitan is a very experienced and seasoned kind of an individual in the kind of a space. INDUSLAW represented by Nishant is, of course, he's equally good. And the Dhaval company, Prachi is representing her company, Dhaval & Co, right? Sorry. And so she handled number of IBC matters as such. And Mr. Sai, representing the Yes Bank, he was in a little tight spot when I requested him to come onto the dais because he needs to speak the truth. It is difficult for anybody to speak the truth. But I said, don't worry about it. I'll cover your back in terms of the truth. And we are here to learn the truth. So that's where Mr. Sai has been roped in. Well, I work for a company called Hindustan Construction Company. And I've been there. And my dear esteemed colleagues are here. So too seniors from the domain. Respects to everybody, because the glaring light, I couldn't call them by name. But yes, I respect each of you. And quite a lot of youngsters on the dais and in the audience. I think that really enthuses me to see as to how well we can take the day's proceedings. Before we start, I'll start with a little story. I'm sure that you all heard about tortoise and hare. Very simple story. When we were kids, we learned about it. But the application of the story runs all through our life. In our personal lives, professional lives, and the domain in which we are talking about. India started very slow in its reforms, very, very slow when compared to the world, like that of a tortoise. But look at the hare, the advanced world, the European Union, or for that matter, the kind of US, they went past and zoomed past in terms of the legislation. Then the tortoise woke up. No, this is time for me also to catch up. So the India imbibed the DNA of a hare and still walking the way of a tortoise, but it's a blend of both the things. So the context is that when we're talking about the legislation, and particularly the IBC, we are going to talk about it, that is a blend of hare and tortoise. We went through the tortoise phase in the form of the SICA Act of 1987, BIFR, SURFACE Act, CDR, Joint Lender Forum, Strategic Debt Restructuring, and S4A. These are all the schemes in the nature of the kind of a tortoise. But what is the end objective? End objective is that India we want to project as an investment destination and a good economic hub to start a business. That's the whole objective. So that be the case, we need to give the world and the investors a confidence that yes, this is a place where we can really safely put our bets on. That is what was shortcoming about 10 years back. Then the governments have changed, but nonetheless, they brought in some changes. That's what the context is about. So finally, the context went into a situation. I have to tell you one more story. The story is that of a miner who was doing the kind of a mining, suddenly he found a stone. He brought that stone home and gave it to his wife. This is a nice stone which I found in the mine. What do you say about it? She said, very lovely. Can you give it to me so that I can do adrak and ilachi tea in the morning for you? She wanted to use that stone for the kind of making a nice masala tea. Then he said, okay, fine, because wife now, he said that, okay, fine, you just keep it. Then the lady started grinding it. Then it started polishing a little better. Then one day she took it to another neighbor and said that, look, this is a stone which my husband got it. Do you think that is something really good? She looked at it and she comes from a trade. She says there is something intrinsic, it is a metal or something in it. So, okay ma'am, why don't you give it to me? Then I'll give you about some 10,000 rupees to it. So this lady parted with that stone. And that other smart lady nicely took that stone and went to a jeweler. The jeweler said that, I'll give you about 5 lakhs. So finally the stone, which is supposed to be a normal discovery in a mine, ultimately turned out to be a diamond in terms of its composition and the value part. The point I'm trying to correlate and connect is that we started a little journey of a stone, but we evolved to that of a diamond in the code of IBC. There are two sides of the story of IBC. One is that people hate it, people love it. The promoters hate it, because it's something like a gully tone for them. And whereas the institutions love it, my yes bank friends would love it, that yes, it is something which they can really protect the public money. Generally, as a public, I think that's a good thing to happen. But for anything, there are two sides of the story. That's where we have with us on the panel the three lawyers who represent the good side as well as the bad side. I'm not saying which is the bad side, who is taking on the bad side, but I want you to take some bad side as well, okay? And the good side to protect the institutions and the public money. So this is a little context in which we went about the IBC. Just for the sake of statistics, a couple of things for you. When India enacted the IBC code in 2016, now we are almost about 30 months. The ease of doing business index has jumped by 30 points because that is what the World Bank and the world institutions felt, that this is something India has come up to age. And that's where we can really, I think that's something in the right step in the right direction. Second, there are a number of investments which are coming into India, and the trust has also grown towards India. I think these are all the contextual settings for us to debate on this kind of IBC. Some feel it's a draconian, some feel it's welcome. So let's see the perspective as to how we really go about it. Now I go back to my seat to put a few questions to my friends. Some are a little discomforting, but be very honest to your answers, okay? Thank you. I will start with Sai, you. Just a generic perspective. How do you feel the institutions or the lenders generally feel about this act? Is it good? Is it still to evolve? Or is it shortcoming in the present context?
Morning, everyone. I'm sure it's audible. Straight to the point, definitely as when I'm hearing from seniors, for me also this is a learning thing. What I feel is, as Mr. Badri has said, it's been evolving, and things like I count this IBC and a couple of the recent judgments also as part of evolving in the last 5-6 years. And I feel the way it has come up, it has definitely helped. The reason is, like, maybe if you have to see one of the World Bank's report, as per the liquidation process, adjudication would take around 5+ years. Now it's not the same situation. Coming into the IBC, coming into the play, I think we have maximum 270 days and we have timelines, and this is benefiting the lenders, and now the lenders are in a higher pedestal compared to others. So definitely this is beneficial. We have our own little shortcomings or evolving. I'm sure the way this has come up, I think the way it started, maybe they thought as we cross the bridge, some of the things would be taken up, like on some concerns on resolution professional or on the segmentation or on the way the value has kept, maybe a 1 lakh and above. Maybe that has cropped up. Lots of litigation. I'm not sure how far the NCLT and the appellate tribunals are geared up to handle that. Otherwise, I feel in a larger context and the way that directionally, I feel this is one of the path-breaking the laws, and this will definitely help the institutions. And going forward, it will become more assertive to the banks and the lenders. I feel this is one of the best laws which has happened in the recent times.
I think you said it without saying, I expected you to say that side, because the institutions are feeling quite a gung-ho about this particular legislation. They're very happy about it, but there are little pinpricks also, which I'll come to you in the next round probably. But in the meantime, I'll just take it from Ashutosh. Ashutosh, the basic question, do you think the IBC is a robust law? Or you think that there are, let me finish up my question. I'm sure that you are jumping with the answer, but before that, you think it's robust, or this robustness has to be a little more robust? How do you feel about it?
I think IBC is still in its nascent stages, and it is an evolving piece of legislation, as has been pointed out by Badri, you, as well as my co-panelist. And the evolution is very apparent from the recent judgments of the Supreme Court also on this subject, where the Supreme Court recognizes the fact that yes, it's an experiment in its self, and it has given a very purposive interpretation to IBC as such, where a lot of its provisions came up for challenge. Some of the very important ones came up for challenge. And by giving it a purposive interpretation, it has sent out a message which is very, very important also for the financial community world over, that yes, India is a place where you can do business safely. That's a very, very, very important message which the Supreme Court has sent out. I think, but still, I feel that it is evolving. There are a lot of issues which need to be put to bed around the IBC, some of it which concern the actions on the part of the resolution professionals, which has led to unnecessary and long-drawn litigation. And some of it relates to how the COC or the Committee of Creditors is functioning and how they are actually discharging that responsibility. Are they taking a very partisan view, or are they taking a view which is in the best interest of all stakeholders? So those are some of the challenges which are there and which the legal system is also very cognizant of. But I think with time we should be able to overcome those.
Nishant, you are operating, INDUSLAW is operating from Bangalore as well as the other hubs as well, but why I touch base this is Bangalore is that Bangalore is centered with the IT industry and the IT domain as such, whereas you are operating from Bombay, I know about it. So apart from the manufacturing sector and the kind of other sectors, vis-a-vis the IT sector, are there any kind of a perceptible comfort levels for the clientele in investing into the IT vis-a-vis the manufacturing sector from an IBC perspective? What is your general take on the statute and how people are perceiving about it? The same question but with a little different context from your angle.
So, as far as the investors are concerned, it's a very
Louder.
opportunistic. Can you hear me? Okay. So, as far as the investors are concerned, it's a very opportunistic play at it, right? Because if you look at the hard asset, power, steel, cement, roads, they have intrinsic value. So the liquidation value is great. If you look at IT companies, some of them do have intellectual properties, but most of them are service oriented. For example, if you look at even Jet Airways, it's a service company, right? They do have some assets which are very intangible assets, like right to fly on certain routes, etc., etc. The only brand is of certain liquidation value. So from an investor's point of view right now, the way we are looking at it, in the IBC, most of the hedge funds that I represent, based out of New York, London, Hong Kong, and some of them from Singapore, they are basically looking at asset-heavy company because it's an experimental stage, and you don't know whether you can preserve the value of the assets when the company goes into IBC. So if it's an asset-heavy company, for sure, the intrinsic value is there, presumably, not necessarily, right? However, if it's a service company, it's very difficult to preserve the value unless you are able to make sure all the main assets, and that's a main HR assets actually, because folks who actually work in the company are the main assets. The customers who work with you, they are the main assets. And if the operational creditors were to run away, if your customers were to run away, if your employees were to run away in service company, it's very difficult to actually do a resolution plan because your value dissipates very fast.
So what you are essentially saying is that for an IT-related company, vis-a-vis the other companies, IT-related company, the domain is a slightly different domain for IBC kind of a processes, because the value need to be preserved, because the asset value is a very short-lived kind of a value.
That's
so
right.
the IBC mechanism has to close on time, then only things will probably better. That's what probably your view, if I guess you right.
More than that, it really depends on very specific assets. So just to give you a little bit of perspective, as when we had the Feb 12 circular, everyone felt this is the most transformational moment in the Indian banking industry, right? Because if you have even a single day of default, you only get 180 days to resolve it. If you're not able to resolve it, it necessarily goes into IBC. It was kind of a nuclear button that RBI pressed, and it was hoped that it will actually create deterrence. But if you look at the core philosophy of IBC, it says creditors in possession, right? So who's losing money is creditors who are losing money mainly, right? So if you do not give optionality in the hand of creditors, which you are seeing right now in the case of Jet Airways, because it's not that there was a default and all the creditors just ran to NCLT, knocking on the door saying that we need to actually preserve the value of this company, right? They are actually invoking the power under projects as such. That's the first case. They are trying to see how they can actually do a pre-pack. Some of the pre-pack amendments are actually on their way from IBB. We will be seeing that. That could actually make the whole process swift. And the fundamental question is, for any deal making, to my mind, there are two important parameters: valuation and certainty. So IBC at fundamental level was supposed to provide that. In terms of valuation, you get a moratorium period, the asset gets some breathing period, right? You are able to see how this melting ice
What's the
cube
second one?
can be frozen.
What's the second one?
The second one is on the timing, right? So you have 180 days, maximum it can be stretched to 270 days, and there are so many assets right now in the court, there's no resolution. So if you look at the time value of money, it's actually
Fine, we'll come to that.
deteriorating,
We'll come to
right?
the process part. Now, Prachi, in terms of your handling the clientele and the kind of an institution of IBC with NCLATs, NCLATs and NCLATs evolving, how do you feel that this statute is of the top order, or is there something else which need to be done to improve the statute or the kind of a mechanism? How do you perceive it?
So, of course, it's a great start. I think the statistics speak for themselves. We've seen a huge number of cases actually being argued, admitted, resolutions coming. So I think the statistics are close to 3,000 admitted, 70 resolution plans out, about 1 lakh crore of rupees worth of resolution plans, which if they get injected will probably help the economy in a huge way in terms of circulation. Nothing is perfect. There are imperfections to everything. We are seeing this as a growing law. One or two areas of the law which we have seen have grown over the period of time. Of course, one of them is this particular distinction between financial creditors and operational creditors. Now, you know, this is something which is so unique to this law. We have not seen this kind of differentiation in any other law or in any other jurisdiction for that matter, you know. And while I do appreciate, and yes, the Supreme Court has laid down that this is an intelligible differentiation.
Can you a little more deliberate on financial creditors versus operational creditors, just for the heck of capturing the essence of what you're talking about?
Sure. So typically what this financial creditor and operational creditor distinction which has been created under the IBC is basically a financial creditor is a person who is given money for time money value, is expecting money back at a particular rate of interest or with a particular return. Whereas an operational creditor is somebody who's supplying goods and services to a particular corporate debtor. Now that's the fundamental distinction. This is very different. So far, we have always seen in all our, you know, the legislation we've had in India, so far we've seen secured, unsecured. That's the parameters we've worked with so far, and that's the parameters internationally we've seen. Now, this is a new parameter. Now, the Supreme Court and the Banking Law Committee has laid down the reasons for why they think it should be done like this. And if I were to broadly say that there are two differences between a financial and operational in terms of the rights that have been given to both of them under the law. And that's on two differential bases. One being that a financial creditor is, of course, a big lender, financial institution, is giving money. At the time of giving money, they are assessing the business. They are assessing the parameters of that particular business. They're seeing the marketability, they're seeing where there are pitfalls, and they are well aware of the business from a bird's eye view perspective. An operational creditor, on the other hand, is only concerned with supplying certain goods, services, and they are only concerned with their sales or their services being accepted and used by that corporate debtor. And therefore does not have that same kind of assessment of the business of the corporate debtor. Now, because of this differentiation, an operational creditor has not been put on the committee of creditors, which is creditor in control now under the IBC. And there is one more parameter because of which the committee and the Supreme Court have said that this should be allowed, and that is because the financial institutions have deeper pockets. And therefore, if somebody has to be in judgment as to whether this business should or should not take a haircut, that person is a person who should be taking that call and not a person who is merely a supplier.
Great. I think that's a wonderful distinction which has come in, I think, which was not there in any one of the acts before. So
Yes.
the subtle distinction between the two puts the bankers actually in a good spot in a way.
Yes,
So-
that's actually what I was just coming to now.
So let me populate the question to Mr. Sai. Sai, now the issue is that the people say that creditor in control versus debtor in possession. So that's a kind of an equation which we have it today. So do you feel that creditor in control is a better syndrome to debtor in possession? What exactly is the perspective of the banks? Before we complete the question, Yes Bank itself has gone through some rough patches in life, finally destabilizing itself. So even banking industry is also subject to this kind of a thing as such. But nonetheless, as a general creditor, as an institution, how do you look at it?
As Prachi was saying, and she nicely summarized the entire thing, this is one of the best steps in the IBC, like putting the creditors in control. Unlike earlier, where we being the financiers, we are the one who are the affected parties, we're never been given that kind of priority as such. This is an act which has been taken care of the financiers in terms of in the COC meeting, they are the ones who take the calls. In terms of prioritizing a list of clearing the debts and all those things, we are in the list. So I feel that this is the best thing which has happened. And further, maybe I may be getting into the next point also, like in terms of the percentage of, while taking the decisions also, while it has been reduced, that is also one of the important decisions I feel it has been taken. The reason is that the majority can play a role. Majority of the financial creditors can play a role in taking a decisions. And when the financiers are in the driver's seat, they normally try to see that the company which is, they try to see that the business runs, and so that they get their debt, the funds would be, they could realize their funds. I'm sure this particular point of creditor in control is definitely one of the best things happened in this IBC.
I think definitely every banker would like to have the control over the company to which they have lent the money. I think that's a fact of life. Everybody wants control and everybody wants to manage her. Yes, that's true. I mean, I'll just remind you the case of Jet Airways, which luckily and fortunately, today Etihad has stepped in to increase their stake from that 24% to whatever be the percentage. And it is the State Bank as lender has driven this one before it is being put under the hammer, under the IBC. But luckily that is one rescue situation which has come, where Jet Airways is into each of our lives. We travel and we keep traveling in Jet Airways. So I think that's a good perspective from an institution. Though as an industry perspective, I come from the industry. I don't like this. I don't want any creditor to look into my books. I don't want any creditor to come in to supervise and direct my actions. I want to have my independence. But yes, there has to be kind of a balance between the situations as such. Now, Ashutosh, back to you in terms of, see, this has created a kind of a good opportunity for mergers and acquisitions also. From a point of view, the overseas investors are looking at a kind of a things which are under hammer, and probably that could be the kind of a game changer in terms of how to drive the best value for our assets in India, for those things which are under them. How do you feel the M&A space in relation to IBC is likely to pan out and likely to give in a positive value?
The M&A space is definitely going to develop so far as the IBC is concerned. The reason why is that today you get an attractive asset at a fairly discounted value. And the transparency that is achieved in terms of price discovery is also something which otherwise in a bilateral M&A deal may not be possible. The due diligence that you are able to conduct on an asset which is being sold through the IBC mechanism is also fairly transparent. You get to see the asset in its entirety. There is an objectivity in terms of sharing of information. But there are a couple of downsides also which have cropped up in the recent past. And that is per se the committee of creditors dithering in terms of taking decisions and taking bold decisions, in terms of taking haircuts and realizing that yes, this is the end of the game. And because of this, actually what you've seen is that while there have been so many cases which have been admitted under the IBC, but there are only 79 cases out of all the cases that have been admitted.
1,200 and odd, probably.
Yes, who have actually gone through a resolution process. who've completed a resolution process. So, and apart from that, you have resolution professionals who've stepped in and who've taken charge over a company. Now, their integrity...
No, we'll come to them. Resolution professionals are one species.
Yes,
we'll
I
come
know,
to that
but
later.
I think they are one of the key factors why the M&A process is not on a very sound footing.
Nishant, how does it sound, the M&A process, to be the kind of a Kickstarter as far as the IBC is a facilitator?
Right. I have a little different point of view actually on the acquisition side. In the IBC process, we are seeing that due diligences are not so transparent because the information flow from the RP side is not so great. Promoters are not cooperating. That's second item. So as much as you are acquiring the asset on as is where is basis, IBC also gives you great benefit when you sink the asset into IBC, take it out, it comes out clean from any past liabilities. So now there are very clear judicial precedent on that. That really helps you as an acquirer to see, oh, there are no past liabilities, all the sins are rinsed off, that's great. But from an M&A perspective, one of the most important things is to make sure that the post-merger integration is great. And in a bilateral transaction, you are able to achieve it if you have a promoter who cooperates with you, or you do not buy out the exact 100%, you do deferred consideration or earn out, so that the promoter has some skin in the game and you're able to achieve integration with that kind of incentive. However, in the IBC, as the situation is very specific, where the promoter is in default, they're barred by 29A to have any kind of equity stake post IBC, that is becoming very challenging. As such. And another important challenge at this stage is, as an acquirer, when I look at an asset, when I sign up for it and when I close the deal, I want to make sure that during that interim period, the value is protected. Now, RP is the guardian of that asset, and what we are finding, the asset is like a melting ice cube. By the time you go into the closing, you're just not finding the asset as it was when you actually put your bid.
Yeah, I take your point. Prachi, what's your quick take on M&A part of it? You think ArcelorMittal taking over the SR Steel and things like that, you think there is a conducive climate for the M&A deals to happen, or the kind of an overseas investors to have the confidence in the IBC process and get into the Indian shores?
I think there's definitely a positive movement that we've seen. There's no denying that. From all the past laws that we have been through over the last 10, 15, 20 years, this is definitely a step forward in the right direction. We have, however, seen that while most have been successful, there are, of course, few which we have not been able to implement in terms of resolution plans. And I feel that one of the reasons, and to take it forward from what Nishant was saying, is that, you know, when you're doing a diligence and when you're pegging a value to a particular asset, you've seen X, Y, Z, but what is happening in reality, while yes, IBC is in that sense, as I like to call it, you know, making the company go through Ganga, like Ganga Nahalya, and everything has come clean. But that's not the reality of things, because what these plans, some of these plans have provisions like adjudicated values of, say, litigation, they are saying will be nil value. Now, there are certain things like, for example, contingent liabilities. They just peg the values at 0. But what is going to happen, and I think we'll see that when the plans are actually implemented, is that some of these clauses are going to be challenged, because there are going to be challenges in saying that a third party who's not at all in any manner a party to this proceeding will have to give up his value entirely. And you know, that's got nothing to do with as such the financial or the operational debt, and these are litigations, there could be government dues, you know, so to write that off, we're going to see. So there are going to be some teething issues, just like we've seen in implementation, in so far approvals and in admissions. We are going to see that curve now, I feel, in the implementation space as well. But having said that, it is still definitely going to be.
So we all agree to the fact that the M&A space is going to open up, but subject to the valuation, which Ashutosh is very keen on. I mean, both of you are very keen on these things. And definitely, yes, that we need to preserve it. But on that note, let me get into the, first is the statute. We all appreciate and admire. Creditors in control, rather to debtors in possession. Now let's look at the percentile kind of a consent. Sai, earlier the consent has been brought down from a 75% to 66% as far as the lenders are concerned. I'm not going into the February 12 circular and how the bankers are going to behave, etc. That's a separate question I'll put to you. But you think that 66% of a lender's consent is a good enough ratio in the amendment that has been brought in, which can facilitate the kind of a view of the creditors?
Definitely, I feel this is a good one rather than from the earlier one. The reason is now, when the more I was saying when answering the earlier question on the same thing, like this will help the majority would come into play rather than waiting for, I mean, the 75% taking, consensus of 75% would be, maybe sometimes it will be a challenging one. So there's a new one of 66, 65%. I feel that it could be anything above 55 to 65 would be even more much better. Maybe in the times to come, it will be further helping us so that the consensus would be much easier. And definitely as part of the entire, this will be done by the financial institutions. I think they'll be looking at the resolution and they'll, I mean, that the time to resolve these issues would be much easier or faster when the percentage comes further down also. So this percentage is definitely will be helpful.
Prachi, the amendment refers to the lenders kind of a status of the home buyers has been captured.
Yes.
So how do you feel about the status of the home buyers, and is it really warranted to have been brought under the IBC? Do you think so?
So I just want to give the audience a little background on what has happened in the home buyer space. So of course, initially, we didn't know whether a home buyer would fit into the two buckets of either a financial or an operational. Then we saw judgment 1 said that financial because you're earning interest. Judgment 2 saying not operational because you're not providing any kind of goods or services. So we've seen a kind of a growth, and finally the Supreme Court said yes, there will be financial creditor, and an amendment came that the home buyers will have a seat and will be classified as financial creditors, but there'll be a separate class with a representative, etc. Now, while all this is, of course, again, a good step, I feel personally that, a home buyer could, while you've said he's a financial creditor, and now what happens to a financial creditor in a resolution process is that he has to put a value and make that a debt. But there could be people who are just home buyers who don't necessarily want money back. What they actually want is a house, and especially in a plotted development. So what the law has right now curated is a space where people have to come and say, this is my claim, and this is therefore the value of my plot. But what if the value is first, I have given something at the time 2 years ago, 3 years ago, the value has, in my opinion, moved. But what would be, firstly, what would be my, in that case, financial debt? Secondly, what if I don't want whatever that may be in money terms? I may actually want that plot. I may actually want that house. How do I put that request in this particular framework? We are finding that it's a little difficult.
Are the DLFs and Amrapalis of the world are somewhere occupying the back of your mind?
No, there is, I think this is going to happen, it's going to shape up. It's still at a very nascent stage of development, but we are going to see something like this come up in the next 6 to 8 months. The Amrapalis and the other ones where the developer was actually not in a position to develop, and the flat purchasers have just taken the money back. And while this discussion has been touched upon in some of the judgments, it's just been short of saying that I want that house. Everywhere it's ended up being into a money claim. But we feel that as home buyers, there should be an option for you to remain a home buyer at the end and maybe pick a resolution.
Why I raise specifically this question is that we are all Mumbaikars, most of them are Mumbaikars, and I'm sure that all of them have put their monies in kind of a real estate, and they will be having a kind of a comfort factor. Not only this community, the whole community of the Bombay and Delhi, they believe in the real estate, they find a big value in this one. I think this is something very good to have been brought it under the domain and scope of IBC. Maybe that's a kind of another window that is open, opportunity, another window of opportunity.
Absolutely.
Now Nishant, I'll just come to you. And there are some people who have been disqualified from bidding under this process. Okay? They are not being qualified to bid. But except there are exceptions to MSME. So MSME exceptions are there. I want you both to really deliberate on, is it a good step not to have allowed the promoters to come back, some classes and some categories, and MSMEs to let it go? So two views about how the promoters cannot come in and MSMEs can still come in.
I think there is a very core financial philosophy behind it. The whole IBC, as Supreme Court said, is an economic piece of legislation. So as I see that amendment of 29A is based on some financial classification. They're big boys, right? And then their MSMEs. MSMEs, mostly, if they have defaulted, I think this kind of built-in assumption to say that.
I think if you can touch base with the SRs kind of an example where the promoters wanted to come back and bid for, but it has been held the other way. I
fair
think
enough.
That
the only problem I have is I'm representing actually bunch of folks in the big cases. Can't take very specific example as such right now. But I think the core distinction law is trying to make under Section 29A of IBC, if you are a promoter or a person rather in default, then you will not be qualified to actually put your bid for the resolution plan under IBC. And law has made an exception for MSME. So in my view, I think at some level, it's very difficult to comment on its fairness because you are actually saying that big boys are bad, as in they defaulted on big loans. Presumably they had much larger loans. MSME is a small industry. Let's not kill it. Let's not kill those promoters. And for that industry to run, you need those promoters. There are many commercial logic behind it. But at the end of the day, yeah, as in that's the exception.
Ashutosh, your review? Should they be in, I have a little soft corner for the promoters. They are the ones who have brought in this industry. And somewhere I have a little soft emotional corner. I am not talking about the financial concerns or something. I have a little emotional connect with the people. Because if you look at, I'm sure that people will accept that SRs are one of the best employers because they have that touch with the human beings and they really love their employees, etc. Similarly, there are some people, the promoters usually have their sweat and blood get into the industry and they love it. So don't you think there should have been an opportunity for them to come back? Except for their devious acts. What is your view about it?
Well, according to me, there is no straitjacket formula. And unfortunately, the scheme of the Act is such that it is edging towards creditor in control and debtor in possession. Yes. So if that is the scheme of the Act, then probably the amendment which has come in by virtue of 29A is in keeping with that scheme.
Then what is the difference between the MSME?
To that extent,
MSME has been let off the hook. MSMEs
yes,
can bid back.
And I totally agree with you that why MSMEs have been let off the hook, because there can be so many combinations and possibilities where actually what has been lost sight of is MSME recognition or certification is not given to companies. They are given to units. And there could be a cluster of units which could be housed in a large company. And that large company's promoter is still entitled to bid, because what he is doing is he is trying to take over control over MSME units. So that's a loophole or a big gap which has been left. The intent is quite well placed in the sense that, okay, we don't want to kill the MSME sector. It forms the bedrock of the Indian economy. It is driving the Indian economy per se. The underlying growth is coming from and it is not only with these few large companies that you see in the headlines very, very often.
I think the underlying philosophy, if I understood correctly, though I don't support, the underlying philosophy could be that let the entrepreneurship little survive and thrive. Because MSMEs are typically a kind of an entrepreneurial class and clan.
Correct.
They are not industrialists per se. Whereas when you talk about the promoters of big companies, etc., they are industrialists per se. Just to draw everybody's attention, the SR steel bid, when it went under the HEMA, I'm sure that all of you are aware about it. The moment the bid started coming in, immediately SR raised its stake. It went up to as high as that, about 46,000 crores. Then they went and fought the battle. Finally, ArcelorMittal has taken over the kind of an asset. And ultimately, it has been kept in their hands as such. So I think the little subtle distinction I wanted to bring in is that the entrepreneurial clan is something which the government wanted to promote, and the industrial clan which wanted to deliberately siphon off or the kind of a kill the industry, but again re-enter at a lower valuation is something which they want. Yes?
I just want to add one point there. Though Section 29A today very clearly saying that defaulting promoters cannot come in, but there is now an interpretation by the Supreme Court in Sustrabin's case for Section 12A, which allows the promoters to actually present a settlement plan. Is quite beneficial to the extent that so far there's legal ambiguity whether anyone who's presenting a settlement plan can actually suffer from the handicap of 29A. The view largely is not. So even if you're a defaulter, you can come under 12A. The only difference is that you require 90% consent of the creditors to actually approve it. So the threshold is much higher, and that's where some of the promoters are actually fighting their battle in the court right now. So time will tell how that shapes up, but
Yeah.
I actually supplement Nishant's view in this, is that while at one point in time you are actually ousting the promoter from wresting control over the company, but then you have a 12A, where the same promoter can regain control over the same asset at a
With
very,
lower
very discounted
lower
value.
valuation. That's what I tried to say.
It's a very, very discounted value, just clubbing up together 90% of the creditors together. And they are happy because today the creditors are also plagued with this issue that, they have NPAs lying in their books. And we all know the RBI norms as to how NPAs have to be treated in a creditor's book. And that is a nightmare for a creditor. And it is they are hoping that, yes, fine, this gets resolved somehow or the other, even if they have to take a 50% haircut. So there is a contradistinction between what 12A is seeking to achieve and what 29A is trying to do.
Okay.
So I agree with Nishant.
Yeah, fine. Good. I think we heard about the IBC and the kind of opportunities versus threats it gives, and the kind of a little shortfalls, if at all I can call them as a shortfall, that is happening. Now let me get into the process of the IBC as such. The IBC has been gate crushed, and I recited the story of the hare in tortoise. We have the DNA of the hare, but we got into tortoise. But anyway, we are moving about it. There is somebody called as an entity called the Resolution of Professionals, RPs. There is a big debate about the RPs and the kind of a value they are delivering to the society in the form of RPs. I just want to have a quick view, Prachi, starting with you, as to what is the role of, how do you feel the RPs are really come of the age or a long way to go? Quick answer.
So I think we put them in a tough spot, to be honest. I mean, this is
Put
a
them in a-
company in a tough spot. This is a company which is already probably belly up, and you've taken a person who has to come to grips with the full business. Why there's been a default, what's the reason, how to tackle it, get everybody together. There are so many, there are promoters who are usually hostile, there's creditors, there's operational creditors who are always going to be literally, running after him, and he can do very little about
Nishant,
it.
do you like the RPs? The way in which they are at the moment?
No, I totally agree with Prachi. I think they have a very tough job, and I think there has to be some changes to that process, because RP is the guardian of the asset, and asset is, like I said earlier, is like a melting ice cube. So you take all the big assets, even a small asset, they're just not equipped to actually handle it.
Your view?
Yeah, well, the ability, the capacity, and the credibility of an RP has come under serious fire. And that is primarily stemming from the fact that, what are the criteria that we have enshrined in the Act for a person to actually become an RP? Okay. There are very, very basic antecedents that have been actually sought for in the Act. 10 years experience as a professional and you can become an RP? Does that actually entitle you to manage a very, very large and complex business environment? And then you see RPs taking very, very arbitrary decisions because they just don't know. They are not aware. They are not capacitated to deal with such issues. So
I'm sure Sai doesn't agree with it. Sai is looking, frowning at both of us.
No,
because
I agree
you have any view to supplement from a banker's point of view?
I agree to a good extent also. Like we have seen, like it's a tough job. It's not an easy one. No doubt about it. But at the same time, we also seen some of the RPs, the way they deal with it is, as we've been hearing, like they've been very arbitrary also. It's becoming difficult to handle them. And when we take it up these matters with the NCLT also, maybe the kind of the cases getting flooded, the NCLTs may not be getting into the details of why they are behaving like. So I think somewhere, because they are into one of the very important roles for for both from the resolution point of or from the institutional point of everything. So I think the responsibility should be further increased on the RPs, and it has to be, the liability or responsibility has to be further increased, and they should be more
I think
code of
it's
has
a
to
fair
become
expectation.
actually,
It's
yeah.
a fair expectation to have the RP to be somebody who can really understand the business, get into the shoes of a promoter, think like a businessman, and really deliver the kind of a value. Because Nishant is very quite concerned about the value proposition part of it. Now, Prachi, just one question to you. There are some many single bidder situations.
Yes.
So how do you tackle the single bidder situations? Should I to go with it, or should I not to go with it, or should I to derail the process?
So we've in fact been in the middle of some of those very interesting situations, and you know, in our experience, even the NCLT has dealt with it quite uniquely. So we had an experience where there was a single bidder, and the value to the company was practically negligible, if not negligible. And what we saw, even in the court, the NCLT itself, you know, invited bids, and even though the law doesn't provide for it, they actually kept a window open that please, anybody interested, come forward. We are seeking value. We want maximization of value. So they kept actually a window of 3 weeks. They actually told the RP, re-send the invitations out. So, you know, we have seen that courts are trying to get that kind of value, even though there was a plan on the table which was COC approved, but given there was no other alternative, the courts were trying to achieve maximization of value. And of course, now what we have seen in CLAT and all the other decisions is that you cannot override the COC's wisdom. That's where the law stands as of today. And therefore, if there is a plan, good, bad, ugly, that's what you have married, you know, and that's what you have to live with. Fair or not, that's the reality of situation, and you know, nobody lives in a utopia. So yes, while we want to achieve maximization, and there are drivers here which should be able to get us that kind of maximization, there may be a situation for multiple reasons where the knowledge is such, or for example, a technology is going redundant, and therefore there is no buyer for it, or the business is such that promoters are key to it and promoters are now being ousted. So there could be things which could lead to a situation where there is practically no bidder, or there is a bidder but at a negligible value. And the law, the way it stands today, is that that's the bidder you have to go with.
Very true. Ashutosh, you want to supplement something?
Yeah, I just want to add there, I think from a deal-making point of view, single bidder situation, the way it can be effectively handled is like you're seeing in Jet Airways right now. So the pre-pack solution, which are happening in the market, where all the lenders will come together, they will just see the feasibility of how this asset resolution can be done, who could be the potential bidders, and the pre-pack amendments are going to come hopefully soon. In that situation, if you identify the potential bidder, do a pre-pack, then you go into IBC. So it's like a kiss, as they say. You go and come out, and IBC will give you all the benefit. And that's where I think the deal making has to be a little more refined.
Also, some new question to you. The income tax department is quite upset with the IBC process. Everybody complains that our dues are not being recovered because IBC, we don't have a secure place, unlike Yes Bank and ICICI Bank. They are quite secured, whereas my income tax dues are not secured under the IBC process. What is your take on it? Is it right?
True.
One, about the income tax department. Second, about the contingent liability part of it. If you can comment on these two things, any contingent liabilities and the recognition of contingent liabilities. One is income tax dues. Second is the status of the contingent liabilities under the IBC.
Well, as far as the why income tax, statutory government dues, they've unfortunately, or fortunately for a corporate debtor, they've been very clearly classified as operational creditors. And there is a recent judgment of the Supreme Court to that effect. This is also an understanding of the fact that today the government, the legislature, is very concerned with the environment so far as the creditors are concerned and what they are faced with, the challenges that they are faced with. The code today is geared up to actually address that particular challenge. And that is probably has been at the top of the mind of the legislature while creating this distinction between a financial creditor and an operational creditor. where government dues have been relegated down to being an operational creditor.
Yeah.
So that is there to stay for the time being, until unless, of course, an amendment comes about. Of course, there are contradictions there as well, where there are statutes which suggest that if there is a government due which is pending, then that government due becomes a charge on the asset of the particular company automatically by operation of law. Okay. It's
But
true.
still there is a little room to maneuver in terms of how the tax departments or some of the dues need to be addressed as such. So I'll come to that point. But definitely the legislation is bound to come on the income tax. Don't worry about it.
Yes.
It is the government which is driving it.
If there is an
so you can
amendment.
expect the next amendment where the income tax will be covered, the government dues will be covered, and to a certain extent operational creditors also could be covered to save the industry as such. But on that note, in the interest of the time, I'm just quickly jumping into the last question. But before I put the questions to you, I'll just put the context for the sake of audience. One, there is a famous, infamous Reserve Bank of India circular of February 12th of 2018, which has put the entire industry into a kind of a shame and guilt that if they really cross their dues by a day from the mandated time limit, then they fall into the category and there is a sweeping changes. But fortunately, there is a judge who is sitting in the Supreme Court. That one gentleman, a Supreme Court judge, has the one who has fixed many holes under the IBC code. The same judge has delivered a judgment that the circular of February 12, 2018 by the Reserve Bank of India is ultra-virus. I think that judgment, I request all of you to read it because it gives a kind of a contextual setting about the IBC and the industry and the judicial view. It's a brilliant kind of a judgment by Justice Nariman along with the brother judge Vivek Sharan. Kindly read the judgment, that's for the information's sake. So coming on to that note, striking of this February 12 circular, Sai, for you to start with. Striking of the February 12 circular and putting the entire onus on the banks or the kind of a financial institutions. Do you think that your relationship with the creditors is something which is sacrosanct, like a husband and wife? We keep fighting, but at the end of the day, we live. Without a wife, a husband cannot live. Without a husband, a wife cannot live. I mean, that's the reality of life. There are a lot of youngsters, so let's say the lovers' perspective. The lovers, you need to have, each one of us need to have some kind of a lover. Be it a physical lover, be it a metaphysical lover. So you think from a relation perspective, striking down this February 12 circular and putting the control back in the hands of the institutions is something which is good for the nation? So that the banks can really develop the relationship effectively? A generic view, not a specific view.
I mean, as you said, no, I've not covered the entire judgment.
No, it's okay, fine. Not necessary.
I'll leave it to...
Fine, but let Prachi just comment on this one.
I think the aim of the act and this legislation was creditor in control, and I think it's the right place to be because they are the right people to make that kind of decision. And I think, you know, what happens is there are too many factors which play on a mind of a creditor to decide whether or not there is hope, whether or not we should take it down under, or we should change the promoter, or this person who's been doing this for the last 20 years has given certain kind of value to this and we should preserve that value. So I think those are the calls and those are the factors that should continue to be the judgment of the creditor, and rather than putting a stone line that this is it. You cross this line and you have to go under.
So your take on striking of the February 12 circular. How do you feel about it?
I agree with Prachi. I think it's creditor's prerogative, what kind of resolution they want, and optionality is inherently valuable. So you have a pre-IBC resolution and you could have an IBC resolution, right? And IBC is just like a nuclear button. So if you want to press it, then the promoters know that since they are in default, they will not be able to actually retain their asset, most likely, right? At the same time, if creditors see that it is possible to actually preserve the value of that asset and possibly to maximize value of their claim outside the IBC, and I keep quoting JET as an example, right? Perhaps they're a better approach.
Ashutosh,
I have a slight distinction in terms of a takeaway from that particular judgment, which has come from Mr. Nariman. The takeaway that I have is that it's kind of raising a red flag. While it is giving control in the hands of the creditor, and it's endorsing that view that yes, it should be at the option of the creditor to do what it feels best, because in an earlier judgment of Swiss Ribbons, Justice Nariman very clearly said that, financial creditors are creditors who are better placed to assess the viability of a resolution plan. While having said that, the red flag that the Supreme Court has raised over there is that the creditors need to deliberate. They need to exercise due care. They need to be cautious about who they take to IBC. It is not as if it's a straitjacket to that extent. There are sectoral challenges, and creditors need to be cognizant of those. Of course, it was directed to the RBI, but the underlying message is also very, very clear. That yes, you need to be cognizant of the sectoral challenges faced by a debtor. You just can't take everybody and anybody. You need to be very, very cautious, and if you are not, that decision will be held to be arbitrary.
I remember the context of Janardhan Pujari. How many of you know about or heard the name of Janardhan Pujari of the Congress government? Excellent, at least one gentleman, two gentlemen. How many? I am sure that quite a few of you know about it. How he ruined the Indian economy in terms of giving a priority lending to the agriculture and completely destroyed the kind of the value proposition, which our Nishant is very keen on, value proposition of the institutions. End of the day, what are the institutions? Institutions are the custodians of your money and my money. So if our money need to be secured, the institution need to be empowered. If the government comes with a directive, just go on distributing to a particular sector. There was a time when it is given to the solar industry. Now you see it is in deep dumps. There is a time when it has been directed to lend towards the power sector. Now it is in deep dumps. Sometimes back it was into the coal sector. Now it is in deep dumps. No doubt there are a governmental orientation to certain institutions, but at the same time, there has to be a mechanism to really retrieve and secure the public money, which is my money. So I think that's what need to be protected. But coming back to the topic of how well we effectively protect it, the lenders now have got a little more arbitrage in terms of, okay, you lend to the priority sector, but at the same time, you are the people who maintain the relationship and ensure that your recoveries and control of the public money is safe and secure. I think that's one powerful message which has come. Now coming back to just a couple of last questions, I think. I was sounded out that I can extend by about 10 minutes. So that's where, thank you dear. So that's why a couple of things. There are about NCLAT benches which are there, and NCLAT bench is one. So there are about 11 or 12 of them now at the moment. I'm not too sure about the number. But how do you think the kind of a coping work these 11 can really deliver? Ashutosh, what's the review?
Well,
number of benches?
Of course, I think the NCLTs and the NCLAT for that matter is inundated with the number of cases that have been thrown in front of them. In fact, because of this, the timelines which have been prescribed in the IBC are not kept with. You are seeing that, there are delays and delays and delays. There are those 12 cases which were earlier cited by the Reserve Bank in its initial circular. The resolution has actually exceeded 400 days.
In a hushed tone, I can say the first dirty dozen.
We
started with a dirty dozen, and now we went to 1,200 plus.
Yeah, so it definitely, there is a need to increase the number of circuit benches. In fact, in the RBI, in that decision where the second RBI circular was struck down, the 12th February circular was struck down, one of the directions of the Supreme Court was to the government that they will establish more circuit benches.
Prachi, you think these 11, 12 benches are good enough, or what is it we can do to really gate crush the mechanism?
No, there's definitely a lot of pressure on those benches, and we have seen, in fact, when you go, we had only 2 benches in Bombay earlier, and now we have 3, thankfully. But, all the company law matters have taken such a beating. In the cause list, when you see a merger, demerger, or an operation mismanagement, is just put right at the bottom, and it really never reaches. And They really are not interested, and they're really trying. The benches are trying to cope with the kind of pressure, but it is hard. And I believe there are going to be, though NCLAT I believe is going to be having certain additional benches in certain other places more than just Delhi. And Bombay, of course, got a third bench, and I think that has helped ease the pressure. But it is such an important portfolio, and this is really driving the market at the moment. So I do feel that in other cities also, like Gujarat and Bangalore, we do need to have more benches there as well.
Okay, fine. I think that's a good thing because, yes, there is a little momentum which is coming in now, but there's a lot more momentum. Nishant, from your value perspective, you have been an ardent proponent of value and value and value. What happens if the value gets destroyed during the period of the IBC proceedings when the matter itself is not taken up for about a year or so? Then how can you, is there a ring fencing mechanism by which the value can be protected? How do you foresee? Are there any suggestions which you can make probably?
So, as I was saying it earlier, unless you do pre-pack with the lenders and the operational creditors, it's very, very difficult to preserve value. And that's what's happening. Most of the assets are actually losing value because it's like a melting ice cube. I'm just coming back to the same example.
I just want to add to that. What is happening is that the promoters, because they know they are going to be thrown out, they are practically injecting all kind of poison pills, and that is eroding value. So given the situation that the promoters have been put into, that preservation of value is, you're literally fighting a wall, because they are going to be blockading every attempt to preserve that value.
I think that's a fair point. Sai, just one little out-of-box question, but at the same time, your take on your lenders forum, when you have a joint lenders forum to have this kind of a deliberations. Just give an insight. If you are keen, just give it. Otherwise, it's left to your choice. What's the kind of a view you take in terms of extending a lifeline to a company which is about to be referred to IBC, or you think that we should give them one more opportunity? I mean, what's the kind of which are the ones which weigh in your mind to extend the inevitable death knell? If you can probably say that, a few things.
I mean, basis few cases which we have dealt in this IBC matters, we feel that, as we said, it's more logical to extend because we can recover rather than having a heavy haircuts we've been taking maybe in previous cases also. So rather than having such kind of haircuts, we feel that we extend, and it'll be like one of the things is we can, we can settle the outside and we can come out of the case and the lenders would be happy and the financial creditors will be happy, operational creditors would be happy, and as such, even the corporate debtors would be happy, they can run their show and the entire system would be working. Rather than going this way or that way rather, I feel that we should extend one more, the time kind of, this is what we feel that.
Excellent. I think from the holistic discussion, what I could gather is that, yes, we have a kind of a balanced review. The statute is helping us in terms of securing the creditor's interest, but at the same time, the lenders have also been given now a kind of a fair chance to look at the relationships they have with their creditors. I think that's where we are just panning out and sending out a message to the world that it's going to be kind of an investor destination, and India is good for business and for ease of doing business. I think that is a message we try to draw. But at the same time, I just wanted to open the floor for a couple of questions, maybe 2-3 questions, either to a specific or to the panel. Yes, sir. Yeah. A couple of questions, please. Mike. Your name and where you come from.
Hello everybody, I'm Navpreet Aluwalia. I'm partner with Khaitan and Khaitan. So my question is to the panel. It's an open question. We were talking about Section 29A and Section 12A, but there is also now what is happening is the Section 230 of the Companies Act.
Yes.
So once the company goes into liquidation, the promoters are coming out with the scheme under Section 230 of the Companies Act and offering settlement. So I just wanted to understand what is the view in that context then.
Prachi, settlement perspective, how do you look at it, the settlement?
Actually, that's a very interesting question. We were trying to, in fact, go down that route in one of our matters that we were before the NCLT. And yes, so the law, the Companies Act was amended, in fact, by the IBC to make sure that the scheme under 230 could be submitted under the IBC Act now. Practically no one has done it, but again, what matters there is the numbers. Now there's 75% of approval required under 230, whereas it's 66% presently under IBC. So like Nishant was saying, so yes, there are avenues available to the promoters, but it's all a number game. So if you can get the numbers, 90 or 75 or 66, maybe you're still in the game. But if not,
Nishant, your take.
I think definitely it's a way back for the promoter
Yeah.
to get in. At the same time, the way I look at it is for the creditor to decide whether it makes sense for them or not. And if they are seeing there's a great recovery, then why not?
Lovely, good. Another question, if anything is there? Yeah, sir, you? Samir, I'll take one more question, total 3 questions. This second and one more.
Thank you. Yes, my name is Manjinder Singh. My question is regarding, we've been talking that this IBC is not promoter friendly, but I would say perhaps some promoters are taking to their advantage. In terms of giving you an example, say one of the...
Now, what's your question? Can you be specific to a question?
Yeah. I have to give the entire scenario, if you permit.
2 minutes.
Yeah. So one of our debtors, so he comes to us, कि मेरे पास I've got this IBC notice, and perhaps the petition has already been filed, and but it hasn't been admitted. So why don't you settle this matter? Because once it goes beyond my control, then you may be getting nothing going by the pecking order. So then we look at the details of the case and go into their MCA website and see that now in their annual return they've addressed the company is doing good, although there has been a slight slowdown. So they've told that we are approaching our creditors, both operational as well as financial creditors, and perhaps trying to settle the matter. Knowing that in this context, how do we, taking from the poisoning the value that was being discussed. So how, as an operational creditor, should we handle this situation in terms of taking the haircuts? For banks, it may be a few percentage, but for the operational creditors, it must be huge.
Ashutosh, can you just give it?
Yes. Unfortunately, as far as operational creditors are concerned, they are sitting out and they are waiting in the wings. But there is a protection or a safeguard which is now built into the IBC, that if there is any liquidation or if there is any resolution plan as per regulation 38, the operational creditors will at least get the minimum liquidation value which they are likely to get, okay, in terms of liquidation. So go ahead.
Yeah, Prachi,
I just want to add to that. So while, yes, operational creditors are not in the driver's seat, but at the same time, the people who are in the driver's seat are not there just to make profit for themselves. They are there to look out for the interest of all stakeholders. That's the, I think, the fabric of the IBC, that they are sitting there so that they can look after all the interests and not just their own interest. So we have in fact been involved in some of the big ones where we have represented operational creditors, and I would say this, that yes, while there may be a haircut that has to be taken and everybody may have to take a haircut, but if the haircut is largely disproportionate for a financial creditor and an operational creditor, then to my mind, and that's my reading of the law as well as the Swiss Ribbons judgment, then that is not what the IBC intended. That the IBC is not intending to shortchange few stakeholders. It's not. So I think there is a mechanism that you can go now. There are judgments which have these precedents, and while there are aberrations in terms of there are plans which do have this kind of disproportionate payouts, but I would say that to my mind those can be challenged, and the courts are looking at IBC as a fair and just mechanism to protect everybody.
Perfect.
What would be your take from the perspective of the financial creditor in this situation wherein the matter has not yet been admitted and you get an offer, similar offer from the promoter to take a haircut basis your future protection of interest?
We will take that question later. And one more question is coming in. Just can you? Yeah, come on. This is the last question of the day.
My name is Shikhar Tukral. I work for Bharat Petro Resources. We are into oil and gas exploration. Normally, our business model is that we work with a consortium of companies and we explore oil and gas. To fund these operations, all the partners have to put money in accordance with their working interest. One of the partners has failed to provide that money, and he has been put into insolvency by his financial creditors. So the contract provides that we are supposed to pay money on his behalf so that the operations can go on. But it also provides that it will always remain a debt from the defaulting party which is owed to the non-defaulting parties. So my question is, if I have to file a claim before the resolution professional for the money that I have paid on his behalf, should I file it as a financial creditor or an operational?
Nishant, can you answer this question? Or it's difficult, then I'll put it to Ashutosh. Or Prachi, anybody?
I think if you're just providing the services, you may have at the back end with your consortium a financial arrangement. But if that goes bust, you will be an operational creditor with the structure which
absolutely.
I understand.
I'm with you.
Yeah.
I'm with you. Prachi, you have any view?
It's hard to say without having seen the documentation, of course, but I do feel that if it is a guarantee that you're giving, then as a guarantor, there is a chance you can explore a financial, but again, you'll have to look at the way it's worded and you'll have to see.
Ashutosh, your view?
I'm with Prachi on this, actually. You might find yourself in the position of a financial creditor, but it all depends on how the documents are structured. Because at the end of the day, what you've actually done is you've subrogated yourself into the shoes of the your consortium partner. So you have made good what the consortium partner fell short of. So you've in effect given a guarantee. Your payout stems from your giving a guarantee. So
I think that's a way, let me put it, that's a very intelligent question. It's a food for thought for everybody, whether you would step into a kind of a financial creditor or an operational creditor. There are both sides, one need to take it, but it's a careful evaluation of the facts and circumstances and your bidding conditions that probably tilt the balance towards one of them as such. So on this note, I'm sure that we could not give you everything about IBC, but nonetheless, some color, some context, some semblance and some jnaan about IBC. I'm sure that you really enjoyed the deliberations. If so, I request you to give the claps. If you don't like, don't give the claps.
I think you guys deserve a big hand. So I think thank you for this great insight. It's been a fantastic session. I think it could have gone on for another hour if we had left it, but unfortunately we have time constraint. But I would encourage that you have the experts right here. Don't lose this opportunity. Catch them after this, yeah. I mean, especially during the breaks, yeah.